want a blanket? All right, we're ready, Chris. Take it away. All right. Let's. Why don't I go into? Yeah, one. How much? How long do you want?
Sorry?
How long do you want?
Okay, can everybody hear me? All right, let's take our seats and so we can get started. Good afternoon, everybody. So we have the afternoon sessions now, and I just want to give a little bit of an overview. So we're kind of at an inflection point now. The morning sessions primarily had to do with the law of war. Now we're kind of making a transition over to the ethics of war. And of course, you can think about those things in many different ways, right? Are they compatible? Are they incompatible? Which one should you care more about? I mean, just once you make the distinction, there are a lot of questions that naturally are raised by that distinction. So we have two folks here who are going to talk about the relationship between the law and the morality of war. And our first speaker is going to be Adil Haque. Adil has been a member of the fellowship this semester that precedes this conference. And we worked through his book. I was going to ask you if you brought a copy of your book, but no, or maybe I didn't ask. It's fabulous. It's not for the faint of heart, but it's well worth your time working your way through. It's wonderful. So he comes to us from Rutgers, and Helen Frowe has come to us from the University of Stockholm, where she runs a center. And so they're both going to be talking to us about the law and morality of war. Okay, so we're going to do 20 minutes each, and we'll have about 20 minutes for questions. We're going to try to be very efficient with the questions, so we're going to try to go through as many as we possibly can. Midshipmen, get ready to get up here, or cadets, get ready to get up here and ask some great questions. Okay, so
Thanks very much. Thanks, everyone, for having me and for being here for this really interesting conference. So today I'm going to talk briefly about three ways of thinking about the relationship between the law of war and the morality of war. So one is the idea of law as a license, that the law of war justifies, authorizes, and entitles one to fight within the limits of the law of war. That's the view that you heard in the previous panel, expressed by Carl Chang, and spoiler alert, it is wrong. The second view is law as constraint. So this is the idea that the law of war tells you what you may not do, and indeed only some of the things you may not do, but does not tell you what you ought to do. It does not exhaust the moral field. It leaves open a range of ethical questions about what is actually the morally correct course of action. It simply steers you away from the worst wrongs that occur in war. And then the final view is law as guidance. And really, this is a version of the constraint view. It's the idea that the law of war is justified insofar as it provides soldiers with reliable moral guidance. That guidance, again, is not going to be complete, but where the law applies, the law will steer you away from the worst violations of the most important moral obligations that you have to other human beings. And that's the view that I'll suggest is the right one. So we heard a little bit in the previous session about the post-World War II legal order. And this is basically characterized by two bodies of international law. So one body of international law regulates the resort to armed force. It prohibits the use of armed force with two exceptions, self-defense and authorization by the UN Security Council. The second body of law regulates the conduct of hostilities, the treatment of prisoners, the administration of occupied territory. That's the LOAC, that's international humanitarian law. And then the question emerges about the relationship between these two bodies of law. And the conventional view is that these two bodies of law are related in two ways. First, by independence. So the law governing the resort to force is independent of the law regulating the conduct of hostilities, and it's independent in at least three ways. So first, the law of armed conflict, IHL, applies irrespective of whether your state is in the right or in the wrong from the ad bellum perspective, whether your state is waging a war of aggression or a war of self-defense. IHL applies either way. Second, content. The rules of IHL do not refer to the legality or illegality of the war as a whole. Right? There's nothing in the categories of IHL that refer to those broader questions. And finally, to a degree, these two bodies of law address different people. Now, to be clear, both bodies of law bind states, but they devolve onto different individuals. So the law governing the resort to force devolves onto the political and military leaders of a state. That's why the crime of aggression can only be committed by such leaders. Whereas IHL devolves upon really everyone involved in military conduct, but in particular, soldiers, sailors, airmen, marine, right? You folks, or soon to be you folks. And a corollary of all of this is that the law of armed conflict, IHL, applies symmetrically. It's the same rules applying to both sides of the conflict, whether they're waging a war of aggression or a war of self-defense. So that's the law. And then a question emerges about how that legal structure maps onto or diverges from moral principles. Now, back in the 1970s, one of our speakers tomorrow, Michael Walzer, provided a moral theory that sought to mirror this legal arrangement and say that morality works in essentially the same way at the level of structure. So I call this view conventionalism. You might sometimes see traditionalism or the orthodox view. So first, Walzer said that as in law, so in morality, the ad bellum, the rules governing the resort to war, are independent of the in bello, the rules governing the conduct of hostilities. So it is perfectly possible for a just war to be fought unjustly and for an unjust war to be fought in strict accordance with the rules. And, again, as a corollary, that the moral jus in bello is also symmetrical. And it is symmetrical in a very important way, that it is a symmetry of rights. So according to Walzer, though there is no license for war makers, the political and military leaders, there is a license for soldiers without regard to which side they are on. It is the first and most important of their war rights. They are entitled to kill. So this is the law as license. Now, why is it wrong? Let me start actually by referring back to Carl Chang's talk earlier. Is Carl still here? Maybe he stepped out. So Carl referred to a number of kind of paradigmatic wars, the American Civil War, World War II. And he suggested that the law of war justified the conduct of Union and Allied soldiers. Right? Very simply, here's the problem with that. The law of war applies symmetrically to both sides of the conflict. So if the law justifies, morally justifies, the conduct of the Union Army in seeking to disestablish slavery, it would also have to justify the conduct of Confederate soldiers in seeking to maintain slavery. If the law of war justifies the actions of Allied soldiers seeking to defeat the Nazis, it would also justify the conduct of German soldiers seeking to preserve and indeed expand Nazi rule. And intuitively, I hope, that has to be wrong. We've made a mistake, right? It can't be that morally you are entitled to fight and kill irrespective of the justice or injustice of your cause, whatever may be the case for law. And that's essentially the alternative view proposed by a group of scholars known as revisionists, of which Helen is a leading example. So on this view, in morality, the ad bellum and the in bello are interdependent. They are inseparable. You cannot separate what is morally right and wrong to do in a war from the morality or immorality of the war itself. This is simply not possible. So think about the war between Russia and Ukraine. Right? There is a basic moral asymmetry between Russian soldiers and Ukrainian soldiers. Russian soldiers have chosen to kill, maim, and destroy in the service of a war of aggression and conquest. Ukrainian soldiers have not. They are seeking to defend their people against this unjust aggression. So from a moral perspective, revisionists say, it is obvious that Russian soldiers are acting impermissibly. They are killing innocent people, not only Ukrainian civilians, but Ukrainian soldiers. Why are Ukrainian soldiers innocent? Because they've done nothing wrong. Nothing to waive their fundamental moral right to life. Moreover, it is, from a moral perspective, it is only possible to act proportionately in the service of a just cause. If your cause is just, it is at least possible that its pursuit could justify collateral harm to innocent people, to civilians. If you're pursuing an unjust cause, then your unjust cause doesn't justify collateral harm, it compounds the unjust harm. It makes it worse. Not only are you killing civilians, you're doing it in order to conquer their country. And so from the revisionist perspective, morally, the in bello rules apply asymmetrically. Only the just side can act morally, the unjust side cannot. And as a result, only the just side can have, soldiers fighting for the just side can have a moral right to fight, and only the soldiers on the just side can satisfy moral constraints. Now, what does that mean for law? So revisionists tended to say that what this means is that there is a basic divergence between law and morality. That in law, the jus ad bellum and the jus in bello have to be independent, right? For very practical reasons. Because if you are a soldier, you might not know whether your cause is just or unjust. Not all wars are as clear-cut as Russia-Ukraine. Some are morally quite messy. And therefore, it is frankly useless to prohibit fighting for an unjust cause, legally prohibit fighting for an unjust cause. And indeed, it might be harmful. First, because if you allow one side to punish the soldiers of the other side because they're fighting an unjust war, well, the other side is just going to do the same thing, right? So if Ukraine punishes Russian soldiers just for fighting, Russia's going to turn around and do the same thing because they're going to concoct some theory according to which really Ukraine is in the wrong and Russia's fighting in self-defense. And the result of this is going to be, as a practical matter, disaster, right? It's going to do more harm than good. And therefore, according to this view, law and morality must diverge. Soldiers must have a legal right to do moral wrong, not because the law reflects deep moral principles, but for pragmatic and ultimately consequentialist reasons. Now, I would suggest that this debate turns to a substantial degree on a mistake. The mistake is thinking that the symmetry between just and unjust combatants fighting for a lawful cause or an unlawful cause, involves a symmetry of rights, and it does not. So just to give us a text, so Additional Protocol 1 to the Geneva Conventions, to which the United States is not a party, says that combatants have, and indeed are defined as having, the legal right, to participate directly in hostilities. And this might seem to support the license view, right? Soldiers are entitled to fight, irrespective of why they're fighting. But when we think about it, that can't be right. So first, what kind of right is this? Well, it can't be what philosophers call a claim right. So a claim right is when, if I have a right, you have a duty. So if I have a right to fight, you have a duty not to stop me, not to resist me, because I'm in the right. Well, it can't be that, because paradigmatic in war, the fact that one side has a right to fight does not entail that the other side has a duty not to resist them. The anticipation is that they're going to be fighting each other. So it can't be that kind of right. It also can't just be what philosophers call a liberty. So if I have a liberty if I simply have no duty not to do something, right? So I'm at liberty to drink this, right? I just have no duty not to. Right? But it can't be that either, because if this right to fight is constitutive of the role of the combatant, it has to be unique to combatants. But civilians also are at liberty to fight. Nothing in international law tells them they can't fight. Therefore, this cannot be the kind of right at issue in this text. So what kind of right is it? It's what's called a legal immunity. All it means is that if you are a soldier and you conform to the law of armed conflict, you cannot be punished merely for fighting. If you can commit a war crime, you can be punished. But if you conform your conduct to international humanitarian law, you cannot be punished simply because you're fighting for the wrong side. So the Russian soldier can be punished if they murder a civilian, but not if they fight Ukrainian soldiers in a discriminate way. Right? Now, that immunity has the same practical justification that we just talked about. It's there because if it wasn't there, war would devolve into mutual punishment, right? Ukraine would punish Russian soldiers for fighting, Russia would punish Ukrainian soldiers for fighting, do a lot more harm than good. So that's why the immunity exists, for pragmatic reasons, but it doesn't reflect some deep moral right, license, or entitlement. So all of this is to say that the law of war is prohibitive. It is a law that prohibits certain conduct but does not permit, authorize, or entitle anyone to do what it does not prohibit. If we had to find a word for it, I would suggest tolerate. IHL tolerates the harmful conduct that it does not prohibit. It leaves a legal void for other bodies of law and for ethical considerations to fill. So that's the constraint view. All IHL offers are a set of prohibitions and constraints on your conduct. So if you are told by a military lawyer that some conduct that would kill or injure some person is legal, don't get too excited. Doesn't mean that it's ethical, doesn't mean you should do it. But what kind of constraint is it and what justifies it? Now, the most familiar view is that what justifies this is humanitarian considerations. These constraints are justifiable because by generally obeying them, armed forces will minimize harm, particularly to civilians, but also to soldiers who are out of combat, who've been taken prisoner, and so on. So it's essentially a kind of rule consequentialism, if you're familiar with that term. So the aim is to minimize suffering in war to the greatest extent practically possible, not to ensure moral action in war, it can't, and not to ensure full respect for moral rights, it can't do that either. Again, remember the Russian soldier who kills the Ukrainian soldier. Violated that Ukrainian soldier's moral rights, but there's nothing the law can do about that, at least nothing that IHL can do about that. It has to leave it to other normative considerations. And so one example of this, or one of this mode of thinking by one of our other speakers for this afternoon, is that the rule prohibiting attacks on civilians is justified because it protects as many people as warring states are willing to spare. Right? Any broader rule would simply be disregarded. So this is just the best we can do. Right? My quibble with this way of thinking is that it explains why IHL is a good thing to have, but it doesn't answer the question, why should you follow the law of war? Right? It explains why in the long run, we're better off with IHL than without. But why should you follow it? Particularly when following it might be risky, burdensome, dangerous, right? Why should you follow the law? So I think we need a justification for the law of war that addresses the individual soldier and explains to them why they should obey the law. And so this is the final model, right? So law is an imperfect moral guide. So on this view, law is justified to the extent that it serves, it provides a service to fighters by helping them to conform more closely to their moral obligations than they could on their own. Better than they could if they relied on their own independent moral judgment. Now, why might that be? So how does that cash out? So if your cause is just, if you're fighting a war of self-defense, and in addition you obey IHL, then IHL will help you to avoid wrongdoing, but not completely, right? Because at a minimum, you will make mistakes. Right? You will think that somebody is a lawful target and they turn out not to be. You will not realize how many civilians are in a building and it turns out there are a number of them taking shelter there, and there's no way you could have known that. Right? So it won't guarantee that morally you keep your hands clean, but at least it will help you avoid wrongdoing. Now, what about if your cause is unjust? What if you're a Russian soldier fighting a war of aggression? Well, IHL can still help you a bit, right? Can't help you that much, but it can help you a bit to reduce the wrongdoing that you will commit. Right? It will at least curb it, but there will be plenty left over. Right? You may avoid harm to civilians, but the Ukrainian soldiers that you kill retained their right to life, and it was wrong for you to kill them. Right? But at least it will help you to avoid the worst. Now, this question. So why? If law does not exhaust morality, why would you follow legal rules rather than just rely on your own moral judgment? So the first reason is the fog of war. So in war, you will have incomplete information, and human beings tend to operate poorly when under certain circumstances of uncertainty. And the law can help you to deal with that, to make the morally least bad decision given incomplete information. And the second is the heat of battle. So if you are certainly on the ground, you will be tired, angry, stressed out, grieving for your fallen comrades. You will not necessarily be in the healthiest emotional state to make a life or death decision for other people. And the law can help you there too. I'm just going to give one example, and this is actually coming off of Lori Blank's comments. So in case of doubt whether a person is a civilian, consider that person a civilian. Why? First, you don't have complete information, and a false positive means you kill an innocent person. It's pretty bad. And the second is you're not in the best emotional state often to deal with that uncertainty, so best to limit your conduct. I'm just going to very briefly point out nevertheless the limits of this view. The limit of this view is that it presupposes that soldiers view opposing fighters and foreign civilians as human beings with equal moral rights to whom they owe moral obligations of the greatest stringency. And if that moral premise is eroded, compliance will fall apart. LOAC cannot survive a combination of impunity and dehumanization. Sometimes soldiers will conform to the law because they're afraid of getting in trouble. Most of the time they'll do it because they think it's the right thing. But if both of those things fail, nothing can help. And we see that today in Gaza. Every war crime imaginable has been committed in Gaza, either by Hamas or by the Israel Defense Forces. Every single one. And I would put to you that the reason is that we have seen this double failure of complete impunity and utter dehumanization. And no law can ensure or even contribute to ethical action once that happens. And so what I want to leave you with is ethics is foundational to law because law can't work without it. So the ethical foundation that you gain in your studies here is what will help you keep your moral bearings in the most difficult circumstances that you will face when you enter the service. Thanks very much.
Thanks, Adil. That was great. Thanks very much to the Stockdale Centre for the invitation to come today, and thanks very much to Ed for all of his organising. So a lot of the work that has been undertaken in the ethics of war over the last 20-odd years, including my own work, has produced verdicts that are at odds with the current laws of war. And some of the ways that Adil just outlined. So, for example, many writers reject the moral equality of combatants, arguing that combatants who fight justified wars do not thereby render themselves liable to defensive harm, and therefore, unlike most unjust combatants, they're not legitimate targets. Yet the law does not distinguish between combatants in this way. Much of my own work argues that non-combatants can be legitimate targets of force, that they, like combatants, can do things that render them liable to defensive harm. Yet the law prohibits targeting non-combatants unless they meet a pretty narrow standard of directly participating in hostilities. So I also think that the concepts of necessity and proportionality are essentially moralized in a way that makes them impossible to capture in a legal framework that doesn't distinguish between justified and unjustified wars. Those who are pursuing an unjustified war cannot, as a matter of morality, permissibly cause any harm as either a means or a side effect of pursuing that war. So this divergence between the morality of war and the laws of war gives rise to an obvious question. Should we revise the laws in order to get greater convergence with morality? By which here I mean moral facts about individual liabilities, rights, and duties. Now, Jeremy Waldron has argued that it's wrong for philosophers to even ask these questions, to sort of openly grapple with them, or has argued that we should at least restrict our doing so to what he calls the quiet hours, rather than times of crisis when public attention is especially directed towards them. Our philosophizing, he argues, could help collapse the laws of war altogether, should it do anything other than cheer for the status quo. Yet Waldron's complaint is partly that the revisionists, like me, are undermining the existing laws without suggesting anything better in their place. And it's hard to know how we might arrive at anything better other than by philosophizing about it. And most of us don't do our best philosophizing in secret, but rather in collaboration and dialogue with others. So the conferences and the publications that Waldron laments as morally and indeed mortally perilous are how we consult with our peers to refine and improve our views. I'm also not sure how often we get the quiet hours of the sort that Waldron envisages. So the most recent war in Afghanistan began when I was a first-year undergraduate, and by the time it finished, I'd been comfortably ensconced as a full professor for 6 years. That period also saw the 2003 war in Iraq, Russia's invasion of Crimea, some Israeli-Palestinian wars, the Israeli-Lebanese war, Yemen, Syria, Sudan. The wait for the quiet time might be long indeed. Now, Waldron worries that criticizing the laws of war will result in combatants engaging in serious wrongdoing, primarily by undermining the principle of civilian immunity. But for those of us who think that these laws currently permit very serious wrongdoing, refraining from criticism is not a way to avoid serious wrongdoing. And precisely because of the high stakes of war, we shouldn't simply grant Waldron's claim that merely critically reflecting on the law, at least in public, will likely make things worse. Now, although I've thought a fair amount about the ethics of war, I don't have settled views on the relationship between the laws of war and the ethics. The current debate largely falls, I think, into 3 rough camps. So when Adil was talking, I was trying to think how well my framework maps onto his. I'm not sure how well it does, but this is kind of how I think of it. So the first camp contains those people who think that the laws ought to closely reflect individual rights and duties, and that the current laws do a pretty good job of this, or they will do if they're interpreted in the right way. So I would put Michael Walzer in that camp, probably Seth Lazar. I'd sort of tentatively maybe put Adil. Adil's a little bit hard to pass, but that's the kind of what I'm calling the current convergence camp. Now, given that I think there's considerable divergence between the current laws of war and individual liabilities, I'm not in the current convergence camp. Now, the second camp contains those who think that the law cannot reflect individual liabilities, and so we need to accept considerable divergence between the law and those kinds of moral facts. Now, this impossibility of convergence with moral facts about liability gives rise to some second-order moral facts, such as a duty to prevent as much harm as we can or as much unjustified harm as we can. And so the current laws of war largely converge with those second-order moral facts and are therefore morally defensible. So I would probably put Janina in roughly this camp, Henry Shue, and I call this the quasi-convergence camp, because what we converge with is these kind of second-order moral facts, but we accept that we can't really track the sort of what we might call the deeper facts about individual liability. Now, the third camp holds that the laws of war ought to reflect facts about individual liabilities, so sort of individual rights and duties and so on, and that the current laws fail to do this, so we should try to revise them. So Victor Tadros and David Rodin are in this camp, which I'll call the revising camp. I also think that Jeff McMahon, who's a very prominent revisionist just war theorist, is also in this camp, although he's often associated with the quasi-convergence camp. Now, the revising camp needn't aim at perfect convergence. There can be justified gaps between the law and morality. But bringing the law closer to facts about individual rights, duties, and liabilities makes it easier to give good arguments for those laws. It also brings the laws of war closer to other bodies of law. At least when these work well, they try to respect and respond to our individual rights and duties, rather than relying on predictions about what might maximize the good or minimize injustice overall. And it serves another important aim of the law, namely of promoting peace and stability, by fostering recognition of the importance of these individual rights and duties. That aim is usually undermined when we assign people rights and duties on the basis of their group memberships, rather than in light of what they have done and why. And more generally, and probably most obviously, the prevalence and scale of war and the gravity of the harms that it involves means that divergence between the law and individual liabilities, rights, and duties involves permitting vast levels of serious unjust harm. Now, if we can bring the law even somewhat closer to the moral facts and thereby change behavior to better reflect those facts, we might avoid a substantial amount of such harm. So there's a kind of presumptive reason then to favor revising over quasi-convergence, although of course these reasons might be defeated. And I can't consider all of those potential defeaters here, but I think at least some of them are unconvincing. However, let me stress, unless it's otherwise unclear, I get that changing the laws of war would be really hard, and it would be really complicated, and it would involve political will of the sort that looks at the moment to be in especially short supply. What I say here is inevitably simplistic and incomplete. In my defense, I only have 20 minutes. Now I only have 15 minutes. But I kind of think it's interesting to think about these questions. It seems like a good forum to ask them. So the dispute between the quasi-convergence camp and the revising camp largely centers on disagreement about what would happen if we change the law. So essentially whether we can get combatants to better adhere to facts about individual liabilities. So, for example, McMahon has argued that revising the laws at present would make things morally worse, resulting in more harm overall. Now, this so-called humanitarian defense of the current laws has been really influential amongst revisionists. So those people who think there's this big gap between the law and morality. But I think that McMahon might be being somewhat unduly pessimistic about the effects of reform. And I also think that attention has latched onto his conditional defense of the current laws at the expense of his more fundamental claim that it is, in fact, imperative that we work to bring the law of war into closer conformity with the morality of war. Now, any changes in legal prohibitions and permissions in war would presumably have to be tied to judgments about their legality rather than about the morality of war. We should thus try to close the gap between legal wars and morally justified wars. Now, this, of course, is just a whole other can of worms. Given constraints of time, again, I'm not going to say very much about that here. Rather, what I want to do is focus on the possible implications of making the following change to the law. So suppose that we make it illegal for people fighting illegal wars to harm or to help to harm combatants or civilians, whether intentionally or incidentally. So in Adil's terms, this would amount to removing the legal immunity for fighting in illegal wars. Now, we could allow some exceptions to this. So legal systems typically allow that there can be legal defenses for breaking the law. But any killings that are undertaken as part of pursuing the illegal war, as opposed to, say, trying to prevent a massacre or the torturing of POWs, would be prohibited. Now, this proposal has the advantage that whilst it reflects the fact that people don't render themselves liable to attack by waging justified wars, and so it better reflects facts about individual liability compared to legalized combatant equality, it doesn't require people engaged in illegal wars to make the kind of fine-grained evaluations about individual liability that are often said to make the revisionist view unworkable as laws. Nor does it increase the legal permissions that are granted to those fighting justified wars in a way that gives rise to the worry that if we do that, then everyone will assume that the more permissive rules just apply to them. So we might ask the following questions about this proposal. Would changing the laws change how combatants behave? And if so, would these changes bring behavior more in line with facts about individual liabilities, rights, and duties compared to the current laws? Now, the first question, would changing the law change behavior, is obviously an empirical question. And this is part of the difficulty of assessing the current laws of war and comparing them to possible alternatives. So many of the important questions are empirical questions about what would happen if things were different, and to a large extent, we're just speculating about that. Now, these speculations can be more or less plausible, more or less informed, of course, but they are essentially hypotheses that we can't really test. Nevertheless, I think we can still perhaps reason our way through some of the possibilities. So some people, like Jeremy Waldron, argue that combatants who currently adhere to the law might well stop doing so if we change the law. So by conceding that the previous law was wrong or imperfect, we'd undermine the law's authority, causing combatants to reject the law as a source of guidance altogether. So on this view, even just combatants, although unaffected by the proposed change, would still be less likely to obey the laws of war simply because the law had changed. And that might well mean that the answer to our second question is that the affected changes in combatant behavior would be bad, because they would move combatants further away from facts about individual liability. Now, this seems like an unlikely reaction to changes in the law. Most bodies of law develop over time, so the laws of war, of course, are no exception to that, without this undermining general adherence. So this is at least just partly prudential. If the laws change, then what one might be punished for also changes. It might also be because people take the law to have independent authority. They might believe that there's reason to obey the law simply because it is the law. And with respect to the laws of armed conflict, it might be because the idea of enshrining moral progress in the law is just familiar from civil society. We don't normally treat the law as some immutable, unquestionable set of instructions, but rather as a malleable tool to be honed in ways that best serve our ends. The fact that our domestic laws evolve pretty much continually doesn't seem to have much effect on how law-abiding citizens are. To the contrary, laws that better align with the moral facts are more morally defensible, as are laws that are subjected to regular scrutiny. Laws that better withstand scrutiny seem more likely to encourage obedience than those that are unscrutinized or poorly defended. We should also, I think, pay attention to which armed forces are currently adhering to the laws of war when making predictions about the effects of changing the law. So Waldron notes that only a small percentage of armed groups have military doctrines, and he argues that therefore the more violations that are committed by these otherwise kind of largely well-behaved groups, encouraged presumably by errant philosophers like me criticizing the laws, will hasten the tipping point at which the whole edifice of rules just collapses. Now, military doctrine isn't the same as law, so I'm not quite sure how this argument is meant to work, which is kind of embarrassing because I realized I actually published the book in which the paper, I edited the book in which the paper was published, so there's a bit of an editorial oversight there. But we might nonetheless wonder why these groups currently follow these doctrines. And it seems likely that they do so because they are well-trained, they are well-disciplined, and they're motivated to avoid punishment. These things just seem unlikely to be affected by mere changes of the law, irrespective of the content of those changes, and so it's not obvious that changes would bring about a general disregard for the law. Now, we might object that changing the law will nonetheless undermine adherence if it makes it too hard for combatants to win. So on this view, any or most current adherence to the law is merely conditional. Combatants obey it only because they believe that whilst it somewhat constrains their actions, it nonetheless preserves a possible legal path to victory. Now, if, as the proposal we're considering suggests, those whose war is illegal have no legal targets, then there is no legal path to victory, and hence the condition for adherence isn't met. Now, how this argument unfolds depends partly on what combatants believe. So if they believe that their war is legal, then they will not believe that prohibiting illegal combatants from fighting makes it any harder for them to win. So there's no reason here for them to abandon the law. What if combatants believe that their war is illegal, or that it will be deemed illegal by an international court or other appropriate body? Now, some people argue that such combatants, thinking themselves kind of damned from the outset, will abandon all restraint, doing whatever they believe will maximize their chances of winning. So again, then, this suggests that any change in combatant behavior will be bad because those whose behavior is affected will cause more unjustified harm than they would under the current laws. Now, this argument seems to rest on two assumptions. The first is that one will evade punishment by winning the war. Now, if this assumption was sound, then it would often incentivize breaking the current laws of war in order to do so, if one could thereby significantly improve one's chances of winning and therefore of avoiding punishment. Rather than seeing the law as having a kind of exclusionary force that just rules out certain courses of action, combatants would be involved in a continual trade-off between obeying the law and trying to win. So this isn't a special problem that arises from changing the law then, but rather a general question of how any law of war is enforced. So a system in which the victor gets to decide who's liable to be punished so that the winners manage to evade punishment seems extremely unattractive. We need not adopt such a system. We could instead develop and improve the system of international courts, using them to prosecute war crimes as we do at present. Now, to be sure, this system already requires an awful lot of improvement. But the fact that changing the laws of war reinforces this demand for improvement cannot be a reason against changing the laws. The second assumption is that there will be no differential punishment for war crimes, that if one's going to be punished for fighting, then things will be no worse if one also engages in, say, a campaign of terror bombing or some massacres, because there's no incentive to refrain from those actions. But of course, we could design sentencing to avoid this, just as we do in domestic law. So the fact that assault is illegal doesn't mean that one might as well finish the job by committing murder, because the punishment for murder is much worse than the punishment for assault. Likewise, criminalizing fighting in an unjust war, an illegal war, needn't imply that one might as well fight with no restraint, because the punishment could be correspondingly worse the more harm one causes. Again, we also need differential sentencing for the current laws of war, that a person has committed one war crime should not make them indifferent to committing others. We can also differentiate punishments for those who surrender, which might counter the worry that combatants who fight illegally will be incentivized to continue fighting the longer than they otherwise would. Now, another possibility, of course, is that if combatants believe that they're legally liable for all of the harm that they cause, then this would incentivize them not to cause any harm. So Adil suggested that most combatants believe that their war is a just war. I'm not sure how true that is, actually. But say they believe that at least it would be deemed illegal by an international court. This would then bear on their willingness to enlist in an armed force, perhaps, that they think is likely to fight illegal wars in the first place. And those who've already enlisted might then face a choice between being punished by their state for refusing to fight or being punished under international law for fighting. If these combatants are motivated to avoid punishment, and they believe that they'll be punished either way, then they might just hedge their bets about the gravity of the respective punishments and which course of action is most likely to result in punishment. If so, then we could make it rational to refuse to fight by punishing fighting more harshly than most states punish refusing to fight, and by making sure that there's a reasonable prospect of being punished for fighting illegally. Now, some combatants might still be more deterred by the prospect of a lesser but imminent harm or punishment. But the bar for changing the law is not whether doing so would stop all combatants from fighting in unjust wars. It's whether it could stop enough to be worth doing, where this assessment is sensitive not only to the immediate consequences of the change, but also the consequences over the long term if combatants do reliably face punishment for fighting in unjust wars. This will not mean that illegal wars are not fought at all, but it could make them harder to fight at all, and it could mean that those that occur are fought by fewer combatants, who in turn are less able to cause harm, fight less effectively, and are less likely to win. Now, we might be skeptical about whether there is a sufficiently realistic prospect of punishment for breaking the laws in order to have a kind of deterrent effect. But any deterrent power that attaches to the current laws must similarly rely on this kind of prospect. Again, this isn't a special problem that arises from changing the laws. If combatants are deterred by the current laws from, say, targeting civilians or civilian infrastructure, even if they're ordered to do so, then this must be because they believe that there is a reasonable chance that they might be punished for doing so. So what if the objection that this deterrent power is conditional on combatants also believing that they can win without breaking the law? So on this view, combatants care more about winning than they do about avoiding punishment, so they break the law if it were the only way to win. But they don't care enough about winning to break the law even when that would make them much more likely to win. They obey the laws, apparently, provided that they can see at least some slim path to victory. So I'm not sure how psychologically plausible this picture is. And to the extent that it seems plausible, I wonder if that's because it too relies on the assumption, which we can and should undermine, that those who win will not face punishment. So it's commonly objected that it's not feasible for combatants to make judgments about the justness of their wars. And this objection is sometimes supported by pointing to disagreement among just war theorists about the justness of a given war. So Jeff McMahon's concern about revising the laws of war stemmed largely from his worry that we lack good accounts of jus ad bellum, the resort to war, that could help us to improve what he calls the currently crude and simplistic laws of ad bellum. But this isn't a reason, I think, to give up on the project of reform, but rather a reason for us to get much better at adjudicating wars and pronouncing them at least presumptively legal or illegal in their early stages. Now, of course, this is no easy task. And as Victor Tadros argues, revising the laws of war means not only revising the laws themselves, but also the wider legal and social institutions and cultures and practices that surround those laws and shape our responses to them. And this is a difficult and long-term project, but the possible payoff of even somewhat curtailing the harms of war is correspondingly important. So even if we reject the feasibility of changing the laws right now, and maybe we shouldn't reject the importance of continuing to scrutinize those laws, the feasibility of changing them in the future, or the moral desirability of pursuing those changes. Thank you.
All right, so 40 minutes, so good stuff. Thank you very much, both of you. And I see a bunch of midshipmen right there in the middle, and I can see some of y'all that can't wait to get up here and ask some great questions. What do you think? There we go.